Dear members, greetings. Welcome to Lending 101. My name is Ferdinand John. And today we're going to continue with our discussion that is focused on credit risk protection or securities. Remember, throughout the entire time, we discuss a number of items that are acceptable to serve as collateral or loan security. And afterwards, we focus our discussion on different charges that are created by commercial banks whenever they want to accept a certain asset as loan security. And just to remind you is that, remember, these charges will depend with the lending policies or lending guidelines of a given bank. Now, of the charges that we discussed, if you were to remember, we discussed charges such as pledge, lien, chattel, and mortgage. And today, the focus of our discussion will be on guarantee. So stay tuned and let's move on with the lecture. One of the charges that are created by banks is known as the guarantee. So we really need to understand the meaning of guarantee. What is guarantee? A guarantee can be defined as a commitment by one person called the guarantor to be answerable for a debt of another person known as the principal debtor in case of default. So from this simple definition here, you can see that there are almost 4 key terms that a banker really needs to comprehend their meaning before he could create what we call a guarantee contract. So from the definition, you can see that there is a guarantor, answerable for a debt, principal debtor, and default. Those are the 4 key terms. Guarantor. Who is this? A guarantor is a third party. This is a person who is different from the principal debtor. Principal debtor simply means the borrower. So a guarantor is someone else who comes to pledge or to place a secondary security over the primary security that was pledged or was deposited by the principal debtor who served as the borrower. That is to say, if for some reasons a banker or a lender is not satisfied with the primary security that was placed to serve as collateral by the principal debtor, then the banker has a right to ask for a secondary security. And in this context, a guarantor can be called in. So once a guarantor comes over, he will enter into a contract promising the banker or the lender that in case of a default, the guarantor will be the one to be liable to repay the debt. So in this context now, we need to understand that a guarantee is a promise to answer for the debt, default, or miscarriage of that particular contractual obligation. The primary liability for the debt is incurred by the principal debtor. This is very important. Therefore, the guarantor will be called in only in the case of default. However, I should insist that whenever we say default, it does not mean that when the principal debtor has defaulted from periodical repayment. By saying that default, that means now we need to call in the guarantor. It means that all other efforts to recover the debt has failed. The banker has tried a number of efforts such as the destruction of the loan, selling of the collateral that was pledged to serve as the security, plus any other effort necessary to recover the debt. If all those have yielded no results, that is the time now a guarantor can be called in order to pay for that particular debt. Therefore, the guarantor incurs a secondary liability. So he will only be liable in case the principal debtor fails to pay. However, if the principal debtor's liability to the bank is void, then the guarantee contract will be void as well. That means the guarantor will not be liable for anything. Again, we need to understand that a guarantee must be evidenced by a written note or a memorandum, and that memorandum must be signed by the guarantor or their agent. Without such written evidence, a guarantee is void. It cannot be acceptable anywhere, and even before the eyes of the law, that means to the court. Therefore, that being the reason, a banker will always create a guarantee in writing, not otherwise. Therefore, in a guarantee, we expect to have two contracts, the main contract and the guarantee contract. Now, let me start with the main contract. The main contract simply means the agreement between the principal debtor, the borrower, and the lender or a banker. So in this contract, the principal borrower agrees to repay a certain amount of money that he has borrowed from the lender at a given interest during a specified period of time. Let's say a borrower, company X, agrees to repay 200 million at an interest of 10% per annum over the period of 7 years. That will be the main contract, the contract between the banker or lender and the borrower. Another contract is the guarantee contract. Now, remember, at the main contract, the banker or the lender might ask for a security, an asset that will serve as a security. Now, if the banker is not satisfied with the asset so pledged, the banker may suggest for that particular contract or that asset to be guaranteed. Now, here is where the guarantor will come over. Now, the guarantor will enter into a separate contract. We call it a guarantee contract. Therefore, there will be a separate agreement between a guarantor and the lender. That is, the guarantor is promising the bank to be liable only in case of default and not otherwise. If it happens that the borrower has fully repaid his debt as per the agreement stipulated on the contract, then the guarantor will be excused. However, if it will be different, then that is the only moment the banker will seek repayment from the guarantor. Now, let's focus our discussion on the important clauses in a guarantee contract. Now, the first clause is known as the consideration clause. We're being informed that any contract must have a consideration, and in this case, consideration is the credit facilities being granted. This clause simply means that the consideration will be the amount of money that has been borrowed by a particular borrower, or simply say borrowed by the principal debtor from the lender or the bank. Clause number 2 is to pay on demand. Now, here there's some issues that we really need to understand before we could move any further. Remember, statutory contracts have a term limit of 6 years under the Law of Limitation Act. But this does not go parallel with the contract that has been signed, the main contract. Remember, main contract is the contract between the banker and the principal borrower. Let's assume that the main contract is for 10 years. Therefore, the guarantee contract will start once the guarantor has received the note of determination. Therefore, if for example the borrower has served his contractual obligations over the period of 6 years and he comes to default on year 7, and the bank has tried all the effort to recover the borrowed funds in vain, and subsequently decided that now it is about time we inform the guarantor. So it is then and only then the guarantee contract will start. That is, on year 7, once the guarantor has been informed that now they are supposed to be answerable for the debt of the principal debtor, that now we count that as year 1 on the guarantee contract. So, by this clause, the guarantor undertake that on a written demand being made to them, they will discharge all monies and liabilities owing by the principal debtor to the bank. Remember, the effect is that 6 years limitation period in which the guarantee can be enforced does not begin to run until a formal demand for repayment is made. I've mentioned earlier that is following receiving the notice of determination. Now, another clause is known as the all monies clause. So what does this mean, all monies clause? The all monies clause makes the guarantor liable for the total amount owing, including all interest and cost, irrespective of the amount demanded. It is usual, however, for this clause to include a limit on the guarantor's actual ability to pay. The banker will always include this clause in order to prevent the guarantor claiming a contribution from any co-guarantors. Where the guarantors have paid only part of the debt, even though this is their proportionate share and or the actual limit specified in the guarantee has been paid. The all money clause prevents the guarantor suing the principal debtor for the amount paid to the banker under the guarantee. Also, it is included because the guarantor is unable to exercise the right of subrogation against proportionate share of any securities deposited in support of the guarantee by the principal debtor or third party. Therefore, these are three main reasons as to why we really need to include the so-called all monies clause under the guarantee contract. Next is continuing security or continuing guarantee. Continuing security is there to prevent the operation of the rule in Clayton's case, and you can simply call this the con clause. What does it mean? This clause ensures that the guarantee covers the outstanding balance at any time and not the specific sum so advanced. Without this clause, every payment would reduce the amount secured by the guarantee, while every payment out would constitute a new debt that would not be covered by the guarantee. If supporting security is held, this clause offers no protection against the subsequent mortgages who give notice to the bank. So again, it's one of the important clauses to be included in the guarantee contract. Next is the termination of the guarantee. We've been informed that the guarantee will remain effective until 3 months after receipt of the notice of determination. Again, I should remind you that the guarantee contract will commence once the guarantor has received notification from the banker that it is time for them to be liable due to the failure of the principal debtor to repay their debt. And once the guarantee contract is started, then it will run 3 months after the end of the guarantee contract. That the 3 months or the 90 days time are supposed to serve as a grace period to ensure that the banker is fully satisfied with each and everything that has been done or supposed to be done under the guarantee contract, and that the contract has been fully satisfied. Now let's see who can give a guarantee contract, who can offer, who can guarantee something or a loan. Number one is a single person. So a single person becomes liable for the entire liability personally. That is to say, now, if company X has been requested by the banker to provide a guarantee, and for some reasons they've brought Mr. Freddy as their guarantor, and Mr. Freddy signs the guarantee contract with the banker as a single person guaranteeing that particular loan. In case of default, it's only Mr. Freddy who will be liable to repay the entire debt. So he cannot request the bank to claim the money or the borrowed funds from someone else. Number two, joint guarantors. Joint guarantors are as well allowed to serve as guarantors. How? Remember, a single person, we're talking of only one man. Now, as the joint guarantor, here we're inviting more than one person. So, can be 2, 3, 4, 5. These persons are simply known as the co-guarantors. In this setting, they all agree to be liable jointly to repay the loan in case the principal debtor has failed to meet his contractual obligations as per the contract. That is to say, now, in case of the co-guarantor, they are liable jointly, and if the lender decides to sue only one guarantor, others cannot be sued. Then we have several guarantors. Now, each guarantor can either be sued for the whole liability in person or with other or without others. If an action for recovery fails against one, the lender can go for other or the rest of the guarantors. That is the meaning of the several guarantors. Remember again, under the several guarantors, we'll have more than one person guaranteeing that particular loan. And in case of the default in the part of the principal debtor, then the banker can go after these guarantors. Then there is joint and several guarantors. Now, under the joint and several guarantors, here, the banker will want these guarantors for them to be full liable. Everyone must sign a guarantee contract. By signing the guarantee contract, which means joint and several liability clause, it means that the banker can recover its fund from any of these guarantors or from all of them in case the principal debtor has failed to meet his contractual obligation. So, ladies and gentlemen, in taking a guarantee as a security, a banker needs to ensure the following. Number one, guarantor acts on his own. That's to say, a banker needs to ensure that the guarantor really understands what he's getting himself into. A guarantor is not coerced nor manipulated. Short of that, a guarantee contract will be nullified because it is void. Number two, the financial standing of the guarantor must be good. This simply means that the person who comes to guarantee needs to have a sound finance. Remember, the guarantor or a guarantee contract is a secondary security over the primary security. So you do not want a guarantor to have some serious financial difficulty. If the guarantor will have some serious financial difficulty, it means in case the principal debtor has failed to meet his contractual obligation as per the contract, the guarantor also won't be able to assist the bank to recover the borrowed funds. Then the guarantor needs to have unquestionable reputation. That is to say, the character, the integrity of the guarantor needs to be excellent, very, very good. Again, if it's more than one guarantor, that means partnership guarantee or joint and several guarantees, then the banker needs to ensure that all guarantors have signed the contract. And if the guarantor is a limited company, number one, the banker needs to consult the memorandum and the article of association. Remember, these two documents are very useful. In this case, the memorandum, the article of association, will assist the banker to understand, to really comprehend rules and regulation and the powers of the directors or the management of the company. So if you really want to be sure that indeed the person who enters into the contract on behalf of the company has the capacity to do so, a banker needs to consult the articles of association. But that is not enough. For a limited company, unless signed under the seal, a guarantor is good if it is signed before a commission of oath. Now, why should a banker take a guarantee? Why do we call for a guarantee? Number one, the borrower has no tangible asset to offer as a security. So in case the banker, that is a credit officer or a loan officer, is done with the appraising a lending proposition and fully satisfied that it is within the interest of the bank to give out the loan, but the only problem is that the loan is not secured by any tangible asset, the loan officer can propose for the borrower to bring over a guarantor. So if the guarantor will be there, then the loan can be released. Number two, as additional security to existing securities. I have mentioned this over and over again, that a guarantor or a guarantee is a security, is the secondary security over the primary security. Therefore, if the banker is fully satisfied that the primary security so pledged is not enough, is not sufficient to cover the loan, then the banker is allowed to call for a guarantee. So the guarantee will be a second security over the existing security. Now, in case, for example, the borrower, the principal debtor, is a company, then the directors of the company can be called in for to serve as the guarantor, that is to serve as the secondary security for the primary security that has been pledged by that particular company. Then another reason is that a tangible asset are being offered by a third party as security. Again, here you need to treat this aspect with precautions. Tangible asset being offered by a third party, that is to say, primary security that has been offered to serve as the collateral for this loan is not really belong to the borrower, the principal debtor. So that being the reason, you can call for a secondary security, and that will be guaranteed, just to be sure that in case the third party withdraw the pledged security, then you have a fallout plan or a backup plan, and that will be the guarantee contract. So unless the guarantee is supported by an asset, the credit is considered to be a clean credit. Now, there are some issues that can nullify the guarantee, that can call a guarantor to avoid the guarantee contract. These issues really need to be comprehended by the banker. A guarantor can avoid or denounce a guarantee by claiming that he signed the guarantee against his will, or that he did not know exactly what the document really meant. And if the guarantor can prove this before the court, it's very likely that the court can reason with him and he can be excused from the guarantee contract. Therefore, it is important now for the banker to understand some of the aspects that can nullify, can assist the guarantor to avoid the guarantee contract. And just to let you know, you as a banker, you really don't want to be into this position. Now, the first aspect is avoidance by the reason of misrepresentation. Now, this happens if some material facts were not disclosed to the guarantor. What does this really mean? Where there was an existing debt but was not disclosed to the guarantor is allowed or can be excused from this guarantee contract. So the point here is that a banker is supposed to sit down for a face-to-face interview with the guarantor and ensure that the guarantor fully comprehends what he or she is going to guarantee. He really needs to comprehend the entire amount, time, interest, and if there is an existing debt under that guarantee contract, everything must be open to the guarantor. Short of that, the guarantor can avoid by the reason of misrepresentation. Again, a guarantee contract can be avoided by the reason of undue influence. What is the meaning of undue influence? Undue influence simply means the act of guiding or influencing the performance of one person. So this is done by another person. That is to say, for example, a father manipulates his son into signing a certain contract under the promise that in the near future the son will be the heir of all the belongings of his father. Therefore, this is not acceptable during the guarantee contract. So, undue influence is presumed to exist between a parent and a child, advocate and a client. However, undue influence is not presumed to exist between husband and wife or banker and customer. So, there is an interesting fact here. Undue influence exists between a parent and a child, but not between husband and wife. Why? It is because husband and wife are considered as a single functioning unit. Therefore, we cannot say that undue influence exists between these two, rather between a parent and a child. In this setting now, a banker is supposed to let a guarantor seek independent legal counsel before he could sign the guarantee contract. So it is very, very important for a banker to ensure this. A guarantee can as well be avoided by the reason of a mistake. That is, if the guarantor did not really comprehend what they were getting into when signing the document. Now, this can be caused by inability of the guarantor to read or to understand the contents of the contract. However, in case of a blind person, if the document was read to them and he signed, then he is bounded by the guarantee contract and he cannot excuse himself from that particular guarantee contract. Now, ladies and gentlemen, let's focus now on the right of guarantor. The right of a guarantor are classified under the following headings. Number 1, as against the lender. As against the lender, the guarantor has a right to pay off the debt at any given time before the debt becomes due. The rights, again, the guarantor had the right to request the bank to demand payment from the principal debtor. But if the bank refuses, the guarantor may pay on and demand payment from the principal debtor, and this is what is being called the doctrine of subrogation. Therefore, just to insist here, if a guarantor has come over to the bank requesting the banker to demand payment from the principal borrower, and for some reasons the banker has deemed fit that the guarantor should repay the debt, then the guarantor can do so and move over to claim the repayment from the principal debtor. However, there is a condition attached to this clause, and that is a guarantor is supposed to pay without being demanded or before the debt becomes overdue. Again, the guarantor has a right to enter into the shoes of the bank. If the guarantor pays all the liability, then he is entitled by the subrogation to the bank's right. What does this mean? It means that if the guarantor has duly paid in full the entire debt, then the banker can hand over all assets that was pledged by the principal debtor to the guarantor. So the guarantor can realize his funds from holding these assets, which were initially pledged to the bank. Again, the guarantor had the right to know the extent of his liability at any given time, or we say at any material time. So the banker is supposed to be full open to the guarantor and disclose all information at any given time in case required to do so. Aspect number 2, right of guarantor as against the principal debtor. Now, as against the principal debtor, the guarantor has a right to be indemnified if he pays the debt on behalf of the principal debtor. As against the co-guarantors, remember, co-guarantors simply means there's more than one person guaranteeing that particular debt. Now, if there is more than one person guaranteeing that particular debt, and for some reasons it happened that one of the guarantor has paid more than his fair share under the guarantee contract, then these rights give him the right to claim the rest of the money so paid from the co-guarantors. Discharge of a guarantee will release the guarantor from his primary liabilities. Remember, a guarantor has promised to be liable just in case the principal debtor has defaulted. Now, if it happened that there are some issues that has occurred in the guarantee contract, then immediately the guarantor can be discharged, can be released from his commitment. Now, what issues can cause or can lead for the guarantor to be excused from his responsibilities? Number 1, a guarantor can be discharged by payment. Discharge by payment simply means that a guarantor or the principal debtor has fully paid the borrowed funds. That is to say, payment now can be done by part, the borrower, or the guarantor. If the debt has been made by the guarantor, do not cancel the guarantee, as the guarantor has a right against the principal debtor. Very important to remember the doctrine of subrogation. If the guarantor is the one who has fully repaid the debt, remember, a banker is supposed to hand over all those securities that were pledged by the principal debtor to the bank. The securities need to be handed over to the guarantor so that the guarantor can claim his money from the principal debtor. However, if it is the borrower himself, the principal debtor himself, who has fully repaid the debt, then the guarantee contract can be cancelled or discharged. Number 2, a guarantee can be discharged by releasing the principal debtor. How does this work? If the lender cancels the guarantee by any reason, the guarantor is automatically discharged unless there was a fraud in cancelling the guarantee. So this is simple and clear. Lender or the banker has decided that he no longer wants to hold onto the guarantee contract and for some reasons cancel out that particular contract. Automatically the guarantor is discharged. Again, a guarantee contract can be discharged by variation of the main contract. This is very important to comprehend. Remember, there are 2 contracts signed here. Contract number 1 is known as the main contract. The main contract is between the lender or the banker and the principal debtor or the borrower. And the guarantee contract, this is the contract between the guarantor himself and the lender or the banker. Now remember, before signing the guarantee contract, the banker or the lender needs to ensure that the guarantor fully comprehending what they are getting into. That is, a guarantor needs to fully understand the content of the main contract, that is the contract between the lender and the principal borrower. Now, in case there is a variation or some changes have been made on the main contract without the consent of the guarantor, then automatically the guarantor will be discharged. Again, the guarantee contract can be discharged by variation of the contract of guarantee. So, variation of the contract of guarantee, here we're talking of the second contract, that is the guarantee contract. I repeat again, we have the main contract, that is the contract between the lender and the principal borrower, and the guarantee contract, which is the contract between the lender and the guarantor. Now, in case of joint guarantees, we have been informed that all guarantors are supposed to sign the contract. Now, remember, this will be included in this what we call the guarantee contract. Now, if the guarantee contract has been changed, that is to say, one of the co-guarantors has been released by the banker without the consent of other guarantors, then automatically that guarantee contract will be nullified, and so the guarantors are discharged. Also, a guarantee contract can be discharged by the change in the legal position. For example, initially the person was simply a sole trader and later move on to become a partner business, or from partnership business into a limited company. So you can see now here we have 3 forms of business organization which have different legal status. Therefore, if you did guarantee a sole trader and now it has moved to become a partnership, automatically the guarantee contract will be nullified because the guarantor did not guarantee a partnership business, rather a sole proprietor business. Or, for example, a guarantor guaranteed a partnership business which has advanced to become a limited company. Automatically, the guarantor will be discharged because they did not guarantee the limited company, rather the partnership contract. Now, let's conclude our presentation by discussing the termination of guarantee. Now, termination of guarantee can be, number 1, by notice. Now, if the termination can be by notice, it means that this first needs to be stipulated under the contract, and the length of the notice needs to be known. That is to say, now, on the expiration of that particular notice, the guarantee will no longer guarantee future liabilities or future debts. However, the guarantor will be required to pay the outstanding liabilities before he could be released. That is to say, all debts or liabilities to that particular date, to the date where the note will expire, needs to be fully repaid before the banker could release the guarantor from his liabilities under the guarantee contract. And by doing so, then the banker is supposed to inform the borrower so that he can make some other arrangement. Making another arrangement simply means looking for another guarantor if the banker will want that particular debt or loan to continue to be guaranteed by someone else. Second, termination of guarantee can be by death of the guarantor. Now, it is pretty simple. If the guarantor who was named under the guarantee contract has passed away and the banker has been notified and proof or evidence of death has been handed over to the bank, then the banker is supposed to terminate the guarantee contract. So, depending with the kind of contract, remember there is personal guarantee, joint guarantee or co-guarantors, partnership guarantees, etc., etc. Now, depending with the kind of contract, and so will be the treatment of that particular contract. So, ladies and gentlemen, this marks the end of this brief presentation on the guarantee contract, where we have seen the creation of guarantee contract, clauses included in the guarantee contract, and issues that can cause the guarantee contract to be nullified or avoided. Therefore, in case there is any part of this presentation that was not more comprehensible to you, please feel free to write down under the comment section, and the presenter will reach out to you as soon as possible. Thank you very much for your time, and good day.